Tonight we have Bhavik Patel, who joined Sandberg Phoenix in 2004. He currently serves as the firm's CEO and chairman of the executive committee. Bhavik's work with the special needs community extends outside the firm. He is the founder and chairman of Families at Ease, a local non-for-profit entity focused on delivering information about programs, services, and resources available for special needs children and their families. Without further ado, I'd like to turn it over to Bhavik Patel.
Thanks, Anne. I appreciate it. And thanks for having me here today. You know, so I've been doing trust and estates, estate planning, special needs planning for a long time, almost 20 years. And I really look forward to these presentations. I do miss them from the live version of them, so to speak. But this is good enough. And my job today will be to try to discuss with you estate planning, the why is estate planning important, the things that can happen if you don't plan, and what are some things you can do to solve for particular goals or objectives that you have. And my presentation today will outline several purposes that people come to me to do estate planning. Through that whole process, doing estate planning when you have a family member with a disability in which you might be needing to get certain public benefits for, or things like that, can be just a unique version of estate planning that's going to require some special needs planning, potentially special needs trust, things like that, that we will we'll talk about today. And then we'll let the conversation kind of go from there. Okay, so we're going to talk about estate planning today. And so I have kind of put on this screen here sort of the top 5, or I would say some of the most common reasons people do estate plans. And it will be really the first 3 that we spend all of our time talking about. But I'll briefly mention the other 2 as well. So as I go into this presentation, I'm going to go through each one of these and kind of talk to you about what the consequences are of not doing anything, and then what are the potential planning opportunities to solve for that issue. Estate tax planning and creditor protection are some popular reasons why people come and do estate planning, but it's not going to be the highlight of today's presentation. Just to give you a 2-second version, estate tax planning, as the current laws state, that you don't necessarily have to worry about significant estate tax planning if a married couple has a net worth of less than approximately $23 million. So given that that is very few of us that have that type of estate, anyone that's below that amount generally doesn't have to worry too much about estate tax planning, at least as the laws are today. And then creditor protection really has to do with making sure creditors or liabilities don't go after your assets. It's only works in particular situations, and it's one that just really probably isn't too relevant for today's conversation. Okay, so going into it, I'm going to jump into planning for incapacity. And just talking to planning for incapacity, what happens if you don't do planning? First of all, I am talking about your capacity right now, not your loved one with disability, but just you, yourself, so me. And if I did not do any planning, if something happened to me where I became incapacitated and I didn't have any kind of planning, then there's a general rule that no adult can make medical and financial decisions on behalf of another adult. So if I were to become incapacitated, and if I did not do any estate planning, then my wife, for example, would not be able to make any medical decisions on my behalf, and also not be able to make any financial decisions on my behalf. So that's a pretty severe consequence for not doing anything. And so if I don't do any planning, how can somebody make my medical and financial decisions for me? And there is actually a process, a court process that my loved one, my spouse, whoever is in your life that would want to step up and take on this role, they would actually hire a lawyer, petition the court for what is known as a guardianship and a conservatorship. These are court processes that ultimately, at the conclusion of the court process, the judge grants legal authority for whoever's asking for that authority to be able to act on my behalf for my medical and my financial decisions. So conservatorship is the court process tied to giving an adult authority to act on behalf of another adult on their financial considerations. And a guardianship is for health or medical decisions. Generally, if one is being proactive, if one was trying to plan to avoid for that process, to avoid for court processes, to avoid hiring lawyers, to avoid getting the court's involvement on what happens to every penny that is in my name if I were to become incapacitated, then the proactive planning would be to do some level of estate planning. And keep in mind, estate planning is not necessarily for the wealthy only, and it doesn't always have to be overly complex. It can be very simple. And in this case, planning for incapacity, let me step back for a second. The reason I think it's important to avoid conservatorships and guardianships is because it does take a lot of time and it does cost a significant amount of money. And so just because I became incapacitated, the last thing I want is to increase the difficulty of my family taking care of me, but also costing more money for them to take care of me. Now, go into what can you do to plan? Well, the most simple way to plan for one's incapacity really is to create a document called a power of attorney. And you would do one both for financial purposes and healthcare purposes. But this is a relatively straightforward document that would essentially name somebody to help make your medical and financial decisions, whether it's right away or whether it's after you have been proven to be incapacitated. On the financial or durable power of attorney, ultimately, you name your spouse. If you're married, that's usually the move. You can name the children if they're capable and mature, fiscally responsible, or some friend or other family member. But this is what is going to allow someone to essentially, best way to describe it is sign your name on a document that is about something not medical and health related, to sign your name on your tax return, to sign your name on a check so that they can pay your bills, or to open up an account or close an account, to deal with your retirement accounts, to deal with your real estate. So here's what's really bizarre. Like most of you on this call, if you're married, you probably own your home with your spouse. So in my case, me and my wife own my home or our home. And that's how it's owned on the deed. Now, if I became incapacitated and we didn't have a power of attorney or anything we're talking about, my wife, who is a co-owner of my home, would not be able to sell it, refinance, or do anything regarding the property because she would not have the legal authority to sign my name on the paperwork that would be required to finance or to sell. So it's a pretty significant thing here that these durable powers of attorneys can really help resolve. The second power of attorney here is essentially a healthcare power of attorney. In Missouri, we often call it a healthcare declaration. That document really has two primary purposes to it. The first part of it is often referred to as a living will, or also called a healthcare directive. And that is basically the part of this document that is declaring your wishes to not artificially prolong your life. In essence, that you want to deal with the quality of your life versus the quantity of your life. And that you're disclosing or you're saying, hey, it is your wishes that you not artificially prolong your life. After generally speaking, the attending physician or the physician in charge of your care makes a medical determination that essentially you have no viability remaining and that there is no situation likely to reverse the situation. So at that point, your directive would kick in and then the hospital staff would know not to prolong your life. The second purpose or the second part, the other major purpose of a healthcare declaration is the power of attorney part. So this is no longer about end of life decision making. It's really about who's going to step into your shoes and make the day-to-day medical and health related decisions if you could no longer make those decisions for yourself. I kind of tell people, think about like Alzheimer's or dementia in this sort of scenario. Someone that might have Alzheimer's or dementia may live for many, many years, at which point, though, someone has to be able to make the decisions that are in the best interest of that individual so that they can be cared for and so on and so forth. Those are the financial and the health power of attorney, those are by far the most likely and needed proactive planning tools to deal with planning for your own incapacity. Other ideas, just to mention them, a trust, which we'll talk about later, is a vehicle where you can have your assets owned by a trust. Your trust then says who's in charge of your trust, so that if something happens to you, someone is named to step into the role and be in charge of the assets that are owned by that trust, all for your benefit, followed by whoever the next tier of beneficiaries are. One more or two more things on this slide is just something to think about when we're talking about your incapacity. And by the way, I'm a lawyer. I'm not a financial advisor. I'm not someone that sells long-term care or disability insurance. But oftentimes when folks are younger, it can be deemed quite practical for people to buy long-term care and disability insurance to be able to have a backup plan to replace a sudden incapacitation moment where there could continue to get some salary based on that insurance. That would be the disability insurance. And then you've got the long-term care insurance, which might be as someone gets older and may need some more care, maybe even a nursing home care, something like that, that instead of draining the assets that in theory you have saved up to provide for yourself, but also the rest of your family when you're not here. And instead, you're now dwindling that asset because of your long-term care. Well, one potential strategy might be to get long-term care insurance to help provide some additional funding for your long-term care needs. That's something to throw out. Avoidance of probate. First of all, what is probate? And so probate is ultimately a court process. And again, every time I say court process, you have to kind of remember that means lawyer, court. It means something that's not going to be fully easy, something that's going to cost money, something that's not going to be very desirable. Probate is literally the process that allows an asset that is owned by a deceased individual to legally move away from the deceased person's name to whatever the legal person's name should be. On average, a probate on average, there's some that happen faster, definitely some that happen longer, but on average, probate probably takes 12 to 18 months. Probate definitely is very costly, very expensive. It's also very public. So everybody's going to know your business if you have to go through probate. And then ultimately, there's a very strong chance that the court or the judge, probate judge, will be involved in estate decisions. Well, if any of you were, like I said earlier, Joey, so if I passed away and I didn't do any planning, I would have to go through probate. That's going to be very disruptive. And the hope that what I was leaving for Joey would actually be there to help Joey right away. A lot of times we have to wait till the probate process is started, maybe even completed, before we could use the money safely or in risk-free for Joey. And so that's a big problem, especially in the special needs world, right? If Joey needs regular attention and resources, and now all of a sudden doesn't have it, there could be a break in Joey's schedule. I mean, there could be all kinds of problems I could foresee. So that's if you don't do anything, anyone who owns anything that is titled just in their name and does not have like a beneficiary assigned to it, then at your passing, that person would have to, their assets would have to go through probate. Here is one of the most important bits of information I could provide you, because I have clients see me all the time and they say, well, I don't have to worry about probate because I got a will. I've done a last will and testament. And so I don't have to worry about probate because my will says everything goes to my spouse. And then after that, it goes to my kids. And so I don't have to worry about probate. So I want to be very clear about this. That is like one of the biggest myths or straight up untruths about estate planning. So a will does not avoid probate. I'm emphasizing that very specifically because if I have out of every 100 clients that see me, I think 75 of them believe that they are going to avoid probate because they have a will. Given that I have however many people I have listening to me right now, that means statistically 75% of you thought that. Now I want to be very clear. A will does not avoid probate. In fact, it does the exact opposite. A will's only purpose is to make sure it directs what happens to the assets that go through probate. And remember, the asset that goes through probate is the asset that is in your individual name with no designation of where it goes at your death. Then it goes to probate. And if you have a will, then the judge will look at that will in probate. And after the lengthy probate process, it will say the new owner of that probated asset should be X. And they'll find out what X is by looking at your will. There are lots of planning opportunities of what you can do to avoid probate. For example, I mentioned earlier, my wife and I own my house, let's say in that example. If I passed away, because my house was jointly held with my spouse, she will get the home without having to go through probate. So jointly held property between spouses or jointly held property between individuals in which there's language that talks about with survivorship on the property itself will go to the joint owner, avoiding probate. Now, if just interjecting a little special needs to this, if I was trying to avoid probate, but I wanted my assets to go to Joey, if Joey and I jointly owned an asset together so that if I pass away, Joey would own it, there's a couple of problems with that strategy. One is the fact that Joey and I own it together means it's also an asset of his. At the same time, it's an asset of mine, which also means it's counted towards Joey's assets that can then potentially disqualify Joey from public benefits. Take it out of the context of special needs now and public benefits. Let's just say me and my sibling, me and my brother owned a bank account together, and we had a joint bank account. True, it avoids probate. When I pass away, it could go to my brother and not have to go through that whole probate process we described earlier. But if my brother were to get in a car accident and got in a lawsuit and got hit with a judgment, that judgment could go after all of that joint bank account in that example. So jointly held property has a lot of negative potential implications. And so I would not solely rely on that approach to avoid probate. Now, there are instances where it makes sense to own probate. Like I said earlier, husband and wife owning an asset together. Husband dies, wife gets it. That all is pretty much what was supposed to happen. That seems aligned with everything, and it avoids probate. So there are some scenarios, but me and my wife owning a property together or a bank account, what if we both passed away at the same time? Or what if I died, then my wife owns it, and then my wife doesn't do anything and then subsequently dies? Then we were back in probate. So just be weary of jointly held property, thinking that you're safe and sound and you're always safe and you'll never have to go through probate. It doesn't work out that way. A beneficiary deed is another way to avoid probate. It applies to essentially your home or other real estate, but it's a piece of, it's like a 1 or 2 page document that essentially says, when I die, I want my home to go wherever, and that will avoid probate. So that's a great, effective way to have the home go somewhere. If it went to Joey, however, just be mindful that there's implications of what could happen if Joey is on public benefits. For example, if Joey was receiving Medicaid and I, upon my passing, transferred my home to Joey via beneficiary deed, the Medicaid will then be able to attach a lien on the home so that when Joey passes away later on, Medicaid can get proceeds from the sale of the home to reimburse itself for whatever it incurred on behalf of Joey. So again, not a real ideal scenario for Joey and kind of how it plays in the special needs arena. But if you had if you had an adult child that wasn't on public benefits, or you had a sibling or someone and you wanted to leave the home to, a beneficiary deed might be a very effective strategy for that. The next planning opportunity for avoidance of probate is what we refer to as a TOD or a POD. That's transfer on death or pay on death. Those are interchangeably used, but they mean the same thing. Some bank might call it a TOD, while another financial institution might call it a POD. But what that is simply saying is at the asset level, you can slap on a designation, no different in your 401k or your beneficiary designation, that essentially says, upon my passing, I want X to receive that asset. And when I pass away, X would just have to show a death certificate to that bank account or the financial institution or whatever asset you're putting this on. And then voila, it would go on to becoming the asset of that individual. This is a great effective way to take a very particular asset and have it go where you think you want it to go. The downside to this is a couple of fold. One, if this was your only strategy to avoid probate, then you would have to do a TOD or a POD or a beneficiary designation on every single asset you own. And then as that changes, you would constantly need to update it. And if you decided to change your mind on who it went to, you'd have to completely go through and change everything. The issue is that there's too many opportunities to miss something and make a mistake, and then you're stuck having to go through probate on whatever assets you missed. The other thing I want to point out is you cannot name Joey as a TOD, POD, or a beneficiary designation recipient, because then Joey would receive that asset when you passed away, and Joey receiving an asset would then disqualify him from public benefits, SSI and Medicaid. I am not really talking about SSI and Medicaid and public benefits in this presentation. I do give multiple workshops for the ARC, and several of them deal with public benefits and understanding those rules and the eligibility rules. But in any event, I'm not talking about that today, but I'm making the assumption that trying to qualify for public benefits is partially an objective of yours if you're at the ARC workshop here today. And so with that said, I'm just letting you know, be cautious of naming Joey as an individual beneficiary of anything, because then depending on what happens when you pass away, it could very much disqualify him from public benefits. The absolute most comprehensive way to avoid probate would be to create what is called a revocable trust, also referred to as a living trust or a family trust. It has lots of names, but essentially a trust in its clearest sense, or in its simplest form, is a contract that's it's basically like an empty box in which you will put your assets into it during your lifetime. And while you're alive, you're in charge of that box. You can lift up the lid, you can put anything you want in it. You can take anything out of it. And while you're alive, you can do anything you want. It's like no different than cash in your pocket. However, the power behind a revocable trust says that when you pass away, the contents of the box will pass on to the next person named as a beneficiary, whether it's equally to all my children, whether it's to my siblings, whether it's whatever. We now know who the next tier of beneficiaries are. And then you also name in the trust who the trustee is, which is the person in charge of it. So you could name the trustee, you could name the beneficiary, and then you now have a mechanism of who can lift the lid up when you're gone, and who and for whose benefit the assets can be used for. And all of that happens without the court's involvement, without probate, without having to worry about any court process. So it's basically a privatized, non-court way to answer who gets what, when, who dies when, and how. Now, again, you don't want to name Joey as a beneficiary of the trust, but what you can do is you can name the special needs trust for the benefit of Joey as a beneficiary of the shoebox or the box that I'm describing, so that whatever is going to go to Joey, let's say I had 3 kids, my wife and I passed away, my trust says I want everything divided in equal shares to my children, except I want Joey's share to go into the special needs trust for his benefit. Well, then if I died with $300,000, I'd have $100,000 going into that special needs trust for Joey, $100,000 to my other child, and $100,000 to my other child. And now we have who I wanted to have the money, but not in a way that disrupts Joey's public benefits. The other beautiful thing about the trust is at the time that you want to make a change, you don't have to go and change all the titling for every asset. You can just change, you can just do a quick amendment to your trust. And basically, let's say I wanted to disinherit one of my 3 kids and I just wanted to go 50-50 to the other 2, then I could just quickly do a quick amendment to my trust and boom. Now that applies to all the assets that are owned by my trust. So it's a very effective, comprehensive, and by far, in my opinion, the gold standard strategy on avoiding probate. So going back to the next reason, the planning for proper disposition of your estate. Those are very fancy words. That's really saying who gets what, when, who dies when, and how. Here's a couple of things, though, you have to be aware of. If I die today and I had no planning in place, then when I die, what happens to my estate is it's going to pass by way of something called intestacy statutes. So every state has intestacy statutes, and every state basically says the same thing. And it says, hey, if you die and you don't have an estate plan, or you don't have beneficiary designations on an asset, then what happens to your estate, we have provided sort of a map for what happens to it. And that's called an intestacy statute. And it's not a very good result. So if I live in Missouri, so if I pass away, Missouri statutes say my estate, my assets that were not in a trust or something like that, not um, designated to go anywhere, then half of my estate would go to my surviving spouse if I had one. And then the other half would go equally to my children. So that's a major problem, because if it went to my child, Joey, then I've just disqualified Joey from public benefits. If what if, forget about the special needs element of it, but what if one of my third went to my daughter, who, and let's say my daughter was 8 years old. Well, a minor child technically cannot receive an inheritance outright. It either has to stay in a trust, if you did one, till they turned 18 or older, or you're going to have to deposit all the money with the court, in essence, and ask the judge's permission on how to use that money for your minor child's benefit until they turn 18, and then they get all the remaining money. There's a lot of problems with what I just said. If any of you have minor children and you don't have your estate plan, I ought to have just scared the living nightmare out of you right there. I mean, that'd be a very scary thing, to have left money to my 10-year-old who cannot, or no one can use it on my 10-year-old's behalf without the permission of the court, which means you're going to hire a lawyer and you're going to have to file a motion every time you're really wanting to spend any money on behalf of that 10-year-old. And then when my 10-year-old turns 18, she would get all the money to do whatever she wants. That's a scary proposition, in my opinion. That's taking it out of the account of the special needs situation. Okay, so no planning means that the state you live in has written a plan out for you, and that plan is half of it will go to your surviving spouse, the other half will go to your children. Given that, again, you're probably here to try to preserve public benefits and all of those types of things for your loved one with a disability, then this would be a very bad outcome. There's a comment that says, imagine if your child is in the middle of a divorce. That's yet another issue potentially, right? Leaving assets to a child and then they subsequently get divorced. There's a really big risk that now part of your inheritance could be argued to be subject to a division of assets that may end up, part of it could be justified to go to the ex-spouse of your child. Again, lots of really serious unintended consequences. If you continue to leave your canvas blank, then there's a preconceived notion of what will happen. And I have yet to find a scenario where that preconceived notion, that backup plan is what anybody I've ever talked to, and I've done probably over 10,000 estate plans. I don't think a single one of them has ever came to me proactively and told me that that's what they would want. So it's a pretty significant moment, I think, to not plan for it. So what can you do? There's a million things that your estate plan can do to plan for the proper disposition of your estate. Think of a canvas sitting in front of you, a blank canvas. And this is your piece of art. And you get to draw whatever you want in order to accomplish what you want with your estate planning, meaning what happens if something were to happen to you with your estate, with your assets. So certain things you can dictate or provide guidance on might be to provide certain restrictions or limitations or rights to your surviving spouse. Think about if you're a blended family. You might need to provide certain restrictions because you want to guarantee that the assets end up going to your children versus your stepchildren, for example, or a combination of all of those. You might want to be cautious about what happens if you leave your assets to your surviving spouse, but then what happens if your surviving spouse gets remarried after you're gone? And then all of a sudden those assets pass on to their surviving spouses who happens to also have kids of his or her own. And then all of a sudden, any chance of anything you were hoping to get to Joey is way over here to your surviving spouse's ex-husband's kids. These scenarios seem crazy, but without conscious deliberation and intention on what you're painting on that blank canvas, these could be real consequences. But these are things you can do, is define the rights, limitations, restrictions, things like that for your spouse. You can also leave your inheritance to your children in trusts, whether it be special needs trust for the purposes of not disqualifying Joey from public benefit, or leaving it in trust for your other children that might be more typically developing for a variety of potential incentives or protection. What if one of your children had a drug addiction or a gambling problem or just fiscally imprudent and you need to leave the money in a trust for their benefit with someone else overseeing it? What if you wanted to provide certain incentives like, hey, you're going to get access to more money if you graduate college, or if you keep a full-time paying job for 2 years, or whatever the case may be. I mean, anything. I've had people say, hey, you'll get your inheritance faster if you get married to a particular denomination, or only if you become a police officer. Or, look, I'm not judging here. It's not my job to judge the plan, but it is to allow you to, with intention, get the piece of painting that you were really intending to draw on that canvas. Also, I would want to potentially protect the money from my kids who might potentially get divorced in the future. Or what if one of my children were to get sued? I don't want that lawsuit to attach to the inheritance I leave. So there's a reason why you might want to leave assets in trust for your children. Planning for particular assets is very important because retirement accounts, for example, here's a very important asset that has a very unique application when you leave it to your surviving spouse or when you leave it to your a beneficiary with a disability versus leaving it to a beneficiary with no disability. First of all, you have to leave certain qualified retirement accounts to your spouse. If you're in a blended family, you might want to leave it to your kids, but you would have to get the sign off or the blessing potentially from your spouse. So just something to know about. Secondly, if you were wanting to leave your retirement accounts to your spouse, that is a very tax beneficial thing to do, because then your spouse would be able to receive the entire amount and roll it over into his or her IRA, which would allow for the money in there to continue to grow tax deferred until they would have to start taking out a required minimum distribution, at which point the amount they would have to take out then would be subject to income taxes. If you leave your retirement accounts to someone that is not your spouse and also someone that is not disabled, then they have to pull all the money out within 10 years. And every amount they pull out will be subject to ordinary income taxes at whatever the ordinary income tax rate is for that year for that individual that's pulling that money out. But they have to pull it all out within 10 years. That used to not be the case, but there was a new law called the Secure Act that created this 10-year rule of when you have to pull all the money out. So there's a carve out to that 10-year rule. It's if you're leaving it to your loved one with a disability, then they get to, and yes, you can do this inside a special needs trust. So you're not disqualifying Joey from public benefits because it's all going to be in a special needs trust, but the IRA does not all have to come out of the IRA. All the assets don't have to come out of the IRA in 10 years. It gets to be measured over the entire life expectancy of Joey. So it's a great way to provide an asset to Joey in his special needs trust that would grow tax deferred longer than if you left it to any of your other children. So very much after learning that, many people might say, well, I'm just making up a number. I have 2 kids and I have $2 million. I'm going to put all of my retirement accounts to Joey's special needs trust, which was worth $1 million, so that everything else is going to go to my other child. So it's truly still 50-50. But now Joey's special needs trust has this tax deferred vehicle where things will continue to grow tax deferred and there will be less income tax consequence. I'm not saying that's what you should do. I'm just saying retirement assets are very particular and there's opportunity to do unique planning that might make sense from a tax planning perspective. Another unique asset, though, I do want you to be cautious about is real estate. I mean, lots of things about real estate. Who's going to use it? Is it going to be used? How will repairs be done? Who's going to pay for those repairs? Who's going to be responsible for it? Hey, should we rent it? If so, what happens to the income? Should it be sold? Should I put it in a business so that if I rent it and the tenant gets hurt, then I'm protected from a liability perspective? I mean, like, what are all these things? I mean, my point is, it's a unique asset, and there needs to be unique analysis done as to what specifically you need done with your real estate so that things are smooth. You know, the one thing I didn't put on these slides that really is the number one reason people do an estate plan, it's because they want everything to be as easy as possible, as smooth as possible, to maintain the family harmony during a time where things are very difficult because someone just lost a loved one. And everything we're talking about today and all of these types of planning options, they're all moving towards that goal of eliminating court processes, eliminating this, making things become as easy as possible, being intentional with your retirement account so people don't have to pay more income taxes, or intentional about the real estate so there's a game plan, so on and so forth. Okay, now I'm going to talk a little bit about the different types of special needs trusts. This is kind of my way of describing special needs trusts. This is not something that you might Google per se and find. But ultimately, there's 2 categories of special needs trusts, 2 broad categories. One is called a reactive category, and the other is called proactive. Now, between a reactive type of special needs trust and a proactive type of special needs trust, by the words I'm using, you can tell which one is the more optimal. proactive. It's always better to be proactive than reactive, especially in the world of making sure Joey doesn't lose public benefits. Now, a reactive special needs trust, there's really one type. I'm being over simple. By the way, we have an entire special needs trust presentation as well. If you ever want to come to that, that gets into more details. Today was estate planning. So that's why I'm talking about estate planning. But just to kind of give you a little broad picture of it, the real only type of reactive special needs trust is what we call a self-settled special needs trust, or a first party special needs trust. It also is referred to as a D as in dog, 4A, D4A. It's a code section, D4A trust. But most commonly, it is referred to as a Medicaid payback trust. And it's just as the name might suggest. It's reacting to a problem that's disqualifying Joey from public benefits. And as a reaction, that usually the reason we're reacting is because Joey got something in his hands. Joey got $50,000 in his hands. Okay. Someone left him $50,000 in inheritance, or you yourself didn't do an estate planning. And as a result, his inheritance from you was $50,000. Whatever it is, Joey now has $50,000 in his hands, and that's a major no-no. It's an uh-oh moment. Uh-oh moment meaning Joey is about to be disqualified from public benefits because he has all of this cash in his hand. And so, oh no, uh-oh means we need to react. And so reacting, reaction, reactive category, Medicaid payback trust. Oh yeah, okay, so what I can do is take that $50,000, Joey can take that $50,000 and I'll create this Medicaid payback trust and I'll put the $50,000 in it. And now I can get my benefits again. Absolutely true statement. What happens is when Joey passes away, anything left in that Medicaid payback trust, that's why I like that name, is because it tells you that anything left over has to be paid back to Medicaid for whatever it expended on Joey's behalf. See, that's not ideal. That's not very proactive. It's not the ultimate dream. It would have been to leave an asset in a trust for Joey's care, let him get public benefits, supplement his public benefits by giving him cash out of the trust to do the things he might really enjoy. But then when Joey passes away, those assets would pass on to the rest of the family or whatever the case may be, not necessarily go back to reimbursing Medicaid. Well, you cannot do that in the reactive category. The other category is the proactive category, and it has what are called third-party special needs trusts. And there are two types of third-party special needs trusts. One is called testamentary, and the other is called a standalone. Testamentary third-party special needs trust is basically a third-party special needs trust that is created after somebody dies. So let's say I created a revocable trust. Me and my wife created a joint revocable trust. And that revocable trust says, when I die, everything stays in that revocable trust for my wife's benefit. When both of us die, everything splits 50-50 between my two children, except for Joey's share is going to go into a testamentary special needs trust. And inside my trust, I have an entire section that says, here is the terms of this special needs trust for Joey that actually comes to life after I die so that it can receive that 50% that I've left for Joey's benefit. That is what a testamentary special needs trust means. Versus a standalone is that I have created that trust to exist today so that I can put assets in it today, not upon my death, but today. And anybody else that wants to leave assets to Joey could leave it to Joey today in that special standalone trust. So one is created upon death and one is in existence as soon as I sign the document that creates it. Why do you pick which one is really the question? And it's one simple question you should ask yourself. And so I want all of you to kind of ask yourself the question or answer it to yourself. It'll be a yes or no, okay? And here's the question. I mean, maybe it's a yes, no, or a maybe, but generally it's a yes or no. Is it possible that during my lifetime, Joey will receive assets outside of his own job from somebody? If the answer to that question is possible, yeah, I think so, or yes, then you need a standalone special needs trust, because that needs to be in existence to gobble up those assets that are being left to him. And so that you can communicate to those people that might leave Joey money to say, you can't leave it to Joey, you need to leave it into that standalone third-party special needs trust. If the answer to that was, it is very unlikely not possible, or no, then you don't need the standalone special needs trust. You can get away with the testamentary special needs trust. Either trust does exactly the same thing once it's created. It's just whether or not assets are going to be left to it while you're alive or after you've passed away for Joey. That's the only reason you'd pick one over the other. Otherwise, they're exactly the same thing. The downside of a standalone third party, meaning the one you create now, is a little bit more expensive to prepare. So you're dealing with a little bit more legal cost in order to prepare the document. But that's it. So that's the distinction between standalone third-party special needs trust and a testamentary third-party special needs trust. Now, keep in mind, both of those are still third-party special needs trust, and they're both in the proactive category. What's powerful about that is that when Joey passes away, the assets do not go back to Medicaid. So that's very important to understand. And third party versus Medicaid payback trust, or first party, third party and first party, all that is really talking about is whose money is going into the trust. If an asset is in Joey's hands and now he's putting that into the special needs trust, that is a first party special needs trust. If the asset was in Grandpa Billy's hand and he's leaving it into the special needs trust, and that's called a third party special needs trust. But you never, ever, 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 ever put assets that were in Joey's hand into a third party special needs trust. So if you have a third party special needs trust for Joey, and Joey is starting a job and he's working, and you take his paycheck and you put it into that third party special needs trust, that is very, very bad. That's going to absolutely blow up the special needs trust, and it's going to all be used to disqualify Joey from public benefits. I'm only stressing that because I've seen that happen many times over. I wanted to open it up to some questions, and I see one. If Joey has a standalone special needs trust, can a windfall from a lawsuit be sheltered this way, or does that end up in a first party special needs trust? A great question. And there's unfortunately it's not a very clear answer. If the lawsuit is by Joey and the settlement or the windfall from a lawsuit is to Joey, then that would only go in a first party special needs trust or a Medicaid payback trust. If, however, there is allocation of the lawsuit windfall to maybe the parents of Joey, then the part that was allocated to the parents could actually put that portion in a third-party special needs trust if they wanted to for Joey's benefit. Joan, go ahead.
Okay. I was just wondering, is it possible to have both of the same special needs trusts and have a third party and a first party trust?
Yes, it is. It is very possible. In fact, let's say you are Joey's mom and you have set up your estate planning, and part of your estate planning is to leave whatever you're going to leave to Joey in a third party special needs trust. And that's fantastic. But let's assume a couple of years ago, someone passed away and left Joey some money. So now Joey has some money in his pocket while there's still a third party special needs trust that could get funded later on. Well, that the money that's in Joey's pocket would go into the first party special needs trust. And then you would have, in essence, both.
Okay. So there's no problem with having two.
No problem with that. If we can avoid ever having the first party special needs trust, great, right?
Yes.
But if you're reacting at that point. You can't be proactive. And so you have to fix whatever you're reacting to. And so it's very common to have both because a lot of people have to react.
Okay. Okay. Thank you.
Yeah. Any other questions or? Yep, I got a hand raised there.
Hi, thank you so much for answering all of my questions, even though some of them are not relevant directly, but it's been great. I wanted to ask you, I recently heard, and I don't know if it's right, if an individual over a certain age receives income, so they're working and they're receiving income, but they are a special needs individual. After a certain age, they can receive all the income they want. I mean, if they want to make $150,000 a year, they can, and they will not lose their benefits. Is that true, or is that only if they shelter it somehow in one of these vehicles?
It's not true, and there wouldn't really be a way to shelter that in any of these vehicles, really, because.
What about a CalAble account?
You could, so that I was going to say, the only thing you might be able to do is put some amount into what is called an ABLE account, which would allow them to save. But even that, you can only put up to $15,000 of it in a year. So someone that was making $150,000 wouldn't get that done. I know that was just meant to be an extreme example. But also the ABLE account can only also hold up to $100,000 before it's used to disqualify Joey from public benefits. And lastly, Medicaid can also attach a lien on the ABLE account money. So upon Joey's passing, Medicaid can get reimbursed. So the ABLE account, in my opinion, is also a reaction category type of strategy. And it's very similar to the concept of a Medicaid payback trust, except for it doesn't cost any money to set one up from a lawyer. And as long as you were going to stay nominal amounts that would not really exceed too much money annually or accumulatively, it would be a preferred potential reaction plan to a Medicaid payback trust. I do truly appreciate everybody's time, and thanks to the ARC for letting me come out here and talk to you.
Thanks, Bhavik. It's always a pleasure.
Absolutely.